The U.S. Supreme Court could take up Illinois' gun and magazine ban with the conference meeting Friday and announced orders lists coming out in, well, we're live here, about 25 minutes from now. And then later on, the court is going to be hearing one case today. The U.S. Supreme Court taking up the idea of Second Amendment rights for nonviolent drug users. So that's what we're going to be tackling here this morning for Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell for this Monday, March 2nd. Can you believe we're already into March? So let's get into it. Obviously, we have Illinois' gun and magazine ban that was enacted back in January of 2023. Multiple lawsuits against that were consolidated into the Southern District of Illinois Federal Court. But that was separate litigation from several other cases that had already been making their way through the courts challenging local gun bans in the state of Illinois. One being law weapons versus Naperville. That case went all the way up and down the judiciary, and it's back at the district level where they're like, well, we have to wait to see what the appeals court does in this U.S. Supreme Court. Another case was the Viramontes case, and that was the case challenging Cook County's gun and magazine. Both the law weapons case and the Viramontes case ultimately wrapped in the state ban whenever the state ban happened, but those cases were filed months before the state enacted its gun and magazine ban. So those cases, obviously, where they're at. And the Viramontes case, separate from law weapons, separate from the Barnett case, the collection of 4 in the Southern District that had a judge declare that the law was unconstitutional, and now it's stuck in the appeals court. The Viramontes case has gone all the way up and down the judiciary. Now it's in front of the U.S. Supreme Court, and it's been put into conference multiple times where the court took it behind closed doors but didn't make a decision as to whether they're going to take the case. We have an opportunity later this morning in just a matter of 23 minutes, if you're watching live, to see whether or not they're going to take that case as the U.S. Supreme Court announces an orders list today. But let's go to the court's page here. You've got the schedule that they have lined up. The court will release an orders list at 9:30 their time. That is 8:30 our time. The court will then convene for a public session in the courtroom at 10 a.m. The justices will hear one oral argument. All right. So after, of course, the live show here, I imagine some of you are going to go and listen to the U.S. Supreme Court's live stream to see what they have to say about the case. And what's the case they're taking up? Well, the case is a case concerning nonviolent drug users and Second Amendment rights. Do they have those Second Amendment rights? It's United States versus Hamani. In that case, it essentially had the U.S. government going after Ali Daniel Hamani, a Texas resident, in August of 2022. The FBI searched the individual's home, found a Glock 9mm pistol plus marijuana and some reports of trace cocaine. Hamani admitted regular marijuana use every day or several times a week. Then he indicated in February 2023 that he possessed a firearm and unlawful use of any controlled substance. So they're challenging a particular section of statute and whether that section that prohibits nonviolent drug users from having a Second Amendment right, whether that violates the Second Amendment, especially after the Bruin decision, which was the New York State Rifle and Pistol Association v. Bruin in New York, that really has kind of changed the scope of how courts are ordered to rule on these types of cases. So how does that idea of text, history, and tradition apply to habitual marijuana users? I mean, that's a question that the U.S. Supreme Court is going to take on in oral arguments today. And so that's going to be happening 10 o'clock their time. That's going to be, 11 o'clock? No, 9 o'clock our time. Yes. No, it'll be 11 o'clock our time. So a little bit later on in the day. But regardless, we're Central, they're Eastern. The question about whether or not the Second Amendment still applies to habitual marijuana users or if they can be kept from having a gun for self-defense at home. So lower courts actually ruled that the statute was unconstitutional. The U.S. District Court did, and the Fifth Circuit Appeals Court dismissed the indictment against Hamani, saying that the statute was unconstitutional as it was applied. So now the Supreme Court has 2 lower courts and their rulings that they're going to have to take into account here. So the Supreme Court granted cert back in October, scheduled oral arguments for this morning. So that's going to be happening this morning. But before that, again, we're going to have the case of Veramontes, whether or not they're going to take the case. We don't know. What's interesting to see here, though, and I do want to pull this up just so you can kind of track along with us. The U.S. Supreme Court has, the list for each one of these cases. Here's the Veramontes case, the docket for it. And here is the Hamani case, the docket for it. Now, the Hamani case, again, filed to the U.S. Supreme Court for cert, which is the request for them to take the case, April of 25. All right, so it goes through and they have their filings. It was distributed to conference once, rescheduled, distributed to conference a second time, distributed to conference a third time, and then it was granted. So 3 different times that it was distributed to conference before being granted. What about the Veramontes case? The Veramontes case, it's been relisted several times. All right, so we have this one that was filed in August of 25, distributed to conference, distributed for conference. So that's twice, 3 times, 4 times, 5 times, 6 times, 7 times. We're seeing this case distributed to conference. Now, while the Veramontes case is possibly being considered by the U.S. Supreme Court, and again, we can find out today whether or not they're going to take the case. The Barnett case, that's the collection of 4 plaintiffs groups suing the state of Illinois for the statewide gun ban. That case, filed in 2023, went through the courts on preliminary grounds. 2024 went back to the district court where they ultimately did have a 4-day bench trial. And the district judge, after that 4-day bench trial, thousands of pages of documents, thousands of pages of testimony, expert witnesses and such, they ruled that the law was unconstitutional. Right now, the measure and the question is at the 7th Circuit U.S. Court of Appeals, which still has not acted on it. Whether or not they're going to wait until the U.S. Supreme Court decides whether they're going to take the Veramontes case, because that involves Illinois' gun ban and Cook County's gun ban, is another question entirely. So that's kind of where we're at in all of this. And I really think that it's going to be an interesting day for those who are concerned about the Second Amendment, especially with the hearing that's going to be happening in the U.S. Supreme Court later on today. So it is Illinois in Focus Daily right here with the Center Square. Wake up with us, get the podcasts, and don't forget to stick around for the Center Square Daily only here with the Center Square. Well, no Veramontes case taken by the U.S. Supreme Court. Orders list is out and looks like it's going to be relisted. While a little bit later on today, they're going to be hearing a case about whether or not Second Amendment rights apply to nonviolent cannabis users. They did, however, also just deny a case about whether or not people with low-level felonies have a Second Amendment. So a couple things happening today and still to develop throughout the day when it comes to the Second Amendment. We'll be back here tomorrow to talk about some of those things and more. I'm Greg Bishop. Be sure to like, subscribe, hit that notification bell, and be sure to tune in later on to the Center Square Daily.